Now let us start with section 4, perquisites not included in managerial remuneration. A managerial person shall be eligible for the following perquisites, which shall not be included in the compulsion of the ceiling on remuneration specified in section 2 and section 3. A contribution to provident fund, superannuation fund or annuity fund to the extent these either singly or put together are not taxable under the Income Tax Act 1961, 43 of 1961. B. Gratuity payable at a rate not exceeding half a month's salary for each completed year of service and encashment of leave at the end of his tenure. In addition to the perquisites specified in paragraph 1 of this section, an ex parte managerial person including a non-resident Indian shall be eligible to the following perquisites, which shall not be included in compensation of the ceiling remuneration specified under section 2 or section 3. A children's education allowance. In case of the children studying in or outside India, an allowance limited to amount maximum of rupees 12,000 per month per child or actual expenses incurred, whichever is less. Such allowance is admissible up to a maximum of 2 children. Holiday passage for children studying outside India or family staying abroad. Return holiday passage once in a year by economy class or once in 2 years by first class to children and to the members of the family from the place of their study or stay abroad to India if they are not residing in India with the managerial person. Leave travel concession, written passage for self and family in accordance with the rules specified by the company where it is proposed that the leave be spent in home country instead of staying anywhere in India. So this all things, the perquisites which are given by the company to the directors shall also be included, and it shall include about children's education allowance, then holiday passage for children studying outside India and leave travel concession. Explanation 1. For the purposes of section 2 of this part, effective capital means the aggregate of the paid up share capital, excluding share application money or advances against shares, amount if any for the time standing to the credit of the share premium account, reserves and surplus, excluding revaluation reserve, long-term loans and deposits repayable after 1 year, excluding working capital loans, overdraft, interest due on loans unless funded, bank guarantee, etc., or other short-term arrangements as reduced by the aggregate of investments, except in case of investment by an investment company whose principal business is acquisition of shares, stock, debentures or other securities, accumulated losses and preliminary expenses not written off. Explanation 2. Where the appointment of the managerial person is made in the year in which company has been incorporated, the effective capital shall be calculated as on the date of such appointment. In other case, the effective capital shall be calculated as on the last date of the financial year preceding the financial year in which the appointment of the managerial person is made. Explanation 3. For the purposes of the schedule, family means the spouse, dependent children and dependent parents on the managerial person. Explanation 4. The Nomination and Remuneration Committee, while approving the remuneration under section 2 and 3, shall take into account financial position of the company, trend in the industry, appointees, qualification, experience, past performance, past remuneration, etc. Be in a position to bring about objectivity in determining the remuneration package while striking a balance between the interests of the company and the shareholders. Explanation 5. For the purposes of this schedule, negative effective capital means the effective capital which is calculated in accordance with the provisions contained in explanation 1 of this part is less than 0. Explanation 6. For this purpose of the schedule, current relevant profit means the profit as calculated under section 198 but without deducting the excess of expenditure over income referred in such section 4. Thereof, in respect of those years during which the managerial person was not an employee, director or shareholder of the company or its holding or subsidiary company. Remuneration means remuneration as defined under defined in clause 78 of section 2 and includes reimbursement of any direct taxes to the managerial person. So from these explanations we can understand about each and every provision which is stated in the act and how it shall be applied in the companies. Remember that whatever is stated shall not be as it is used. There shall be some changes which shall be made earlier. Now next we shall be started with section 5, remuneration payable to a managerial person in two companies. So remuneration payable to a managerial person in two or more companies. Subject to the provisions of section 1 to section 4, a managerial person shall draw remuneration from one or two companies provided that the total remuneration drawn from the companies does not exceed the higher maximum limit admissible from any one of the companies of which he is a managerial person. Part 3. Provisions applicable to Part 1 and Part 2 of this schedule. The appointment of remuneration referred to in Part 1 and Part 2 of this schedule shall be subject to approval by a resolution of the shareholders in a general meeting. The auditor or the secretary of the company or where the company is not required to appoint a secretary in the whole time practice shall certify that the requirement of this schedule have been complied with and such certificate shall be incorporated in the written file with the registrar under subsection 4 of section 196. The central government may by notification exempt any class or classes of companies from any of the requirements contained in this schedule. So the remuneration payable to a person in two companies shall be provided. Total remuneration drawn from the both companies shall not exceed the maximum limit admissible by the Companies Act. Then provision 3 states about appointment and remuneration in part 1 and part 2 of the schedule and shall be subject to approval by a resolution of shareholders in the general meeting. Then the auditor or the secretary of the company or where the company is not required to appoint a secretary, then a secretary in whole time practice shall certify that the requirement of the schedule have been complied with and such certificate shall be incorporated in written file with the registrar. So with this we come to the end of first chapter, that is management of company, and after this now we shall be starting immediately with the second chapter. The second chapter is key managerial personnel. So KMP. Now what do you mean by KMP? KMP means the people who have been given a special authority. Let us understand more about them in the chapter. Introduction. Key managerial personnel. The term key managerial personnel has been introduced in the Act of 2013. It takes in the territory or border set of officials who play a major role in the corporate affairs in the light of the new corporate world. The board of directors is responsible to take major decisions related to the affairs of the company. However, the board of directors can take decisions when the periodical meetings take place. As the board cannot look after the day-to-day affairs of the company, this task of the company is entrusted to the key managerial personnel and other managers or executives. Key managerial personnel. Meaning of key managerial personnel. The key managerial personnel in relation to the organization includes the chief executive officer CEO or the managing director MD or the manager, the company secretary CS, the whole-time director WTD, the chief financial officer CFO, and other such officers as may be prescribed. The old Act 1956 did not define the term KMP. According to the accounting standard AS 18, KMP is defined as a person who has the authority and responsibility for planning, directing and controlling the activities of an entity directly or indirectly, including any director, whether executive or otherwise, of the entity. With AS 18, the importance of KMP was duly recognized, and it became necessary for the companies to make disclosures about the various transactions with the KMPs. Role of KMP. The status of KMP is like an officer of the company as well as an officer in default. It is the responsibility of the KMP to ensure that the provisions of the Companies Act are complied with. These responsibilities of various key managerial personnel are specified in the Act. Role of KMP as an agent of the company. A KMP can enter into contracts on behalf of the company. He will be in a position to act on behalf of a company like a corporate agent. The capacity of the agent and his role will be determined by the general law of the agency and the specific rules of the company law. So now we will understand about the key managerial personnel. Now the people who are included under the term key managerial personnel are: firstly is the chief executive officer, that is CEO, the managing director or the manager, company secretary, whole-time director and chief financial officer. These all people have been given importance after the Companies Act 2013 came into existence. Now key managerial personnel have the authority and responsibility firstly of planning, directing, controlling and activities of any entity, whether directly or indirectly, and their importance is duly recognized under section AS 18, and it is necessary for the companies to make disclosures about the various transactions with the KMPs. Now let us understand about appointments and removal of KMPs. The conditions for appointments and removal of KMPs are as follows. Subject to the provisions of the Act, a chief executive officer, manager, company secretary or chief financial officer may be appointed by the board for such a term at such a remuneration and upon such conditions as it may think fit. And any chief executive officer, manager, the company secretary or chief financial officer so appointed may be removed by means of a resolution of the board. A director may be appointed as chief executive officer, manager, company secretary or chief financial officer. Regulation 77 of Table F of Schedule 1. Though the director can be appointed as key managerial personnel, he cannot sign or authorize anything in two different capacities. This fact is clear in Regulation 78, which states a provision of the Act or these regulations requiring authorizing or thing to be done by or to the chief director and chief executive officer, manager, company secretary or chief financial officer shall not be satisfied by it being done by or to the same person acting both as the director or as in place of the chief executive officer, manager, company secretary or chief financial officer. In other words, a person who is not a director can be appointed as the chief financial officer, CFO and secretary or CEO and secretaries of CFO and CEO. Mandatory appointments were of MD, WTD, manager, CEO and secretary. Every company belonging to a certain class or classes of the company should have the following whole-time KMP: MD or CEO or manager, or in the absence were full-time director and company secretary and chief financial officer. Now let us understand each one of them in detail. So first we have is managing director. In a company form of organization, it is the responsibility of the board of directors to direct, manage and control the affairs of the company. However, in reality, it may not be feasible or practicable for the board to conduct, manage and supervise each and every activity in the day-to-day administration of a company due to various reasons such as the directors may not have sufficient time at their disposal for one company because a concerned director may be a director of some other companies also. According to the Companies Act 2013, a person can hold office as a director to as many as 20 companies. We have already studied about these provisions in the first chapter. Then next that we have is there is no statutory obligation upon the directors to attend every company. The board meetings are not conducted so frequently. However, the company's business is required to be monitored on day-to-day basis. Due to such reasons, it becomes necessary for the company to appoint professional managerial personnel prior to April 3rd, 1970. The managing director, managing agent, secretary, treasurer and manager were recognized as professional management person. However, after 1970, companies could not also appoint a manager, director or a manager according to section 196(1)(a) of the Companies Act. Companies cannot appoint both a managing director and a manager simultaneously. However, company can appoint either a managing director or a manager at a time. Definition: managing director means a director who, by virtue of the articles of the company or an agreement with the company or a resolution passed in its general meeting by the board, its board of directors entrusted of substantial powers of the management of the affairs of the company and includes a director occupying the position of a managing director by whatever name called. Explanation: for the purposes of this clause, the power to do administrative acts of a routine nature when so authorized by the board, such as the power to affix the common seal of the company, to document or to draw and endorse any check on the account of the company in any bank, or to draw and endorse any negotiable instrument, or to sign any certificate of share, or to direct registration of transfer of any share, shall not be deemed to be included within the substantial powers of the management. The managing director is a person to whom substantial powers of the management have been delegated by the board, and hence such powers can be withdrawn or otherwise altered by the board at will. So remember that the managing director has a variety of roles to be played, and in a company, if they have appointed a manager, they cannot have a managing director. Either of the two, one can be appointed, and he shall have the prescribed duties and he shall work accordingly. Now let us study about whole-time directors. Meaning, the term whole-time director, managing or whole-time director has been defined in many sections of the Act as per section 294. So, whole-time director includes a full-time director of the company, hence he is the person who devotes most of his time and attention in carrying out the affairs of the company as are assigned to him by the board of directors. A whole-time employee, when appointed as a director of the company, is in a position of a whole-time director provided he is vested with any of the managerial powers. Therefore, a whole-time director is virtually a managing director, though not so designated, if a company is appointed to act as a technical advisor or works a manager or legal advisor or sales manager or finance manager on a full-time basis. He may be treated as a whole-time director in the Inland Revenue Commission versus D. Devine and Sons Limited 1963 AC 557. However, a person who does not devote substantially the whole of his time to the company may be termed as a whole-time director. So far as appointment and reappointment, remuneration, disqualifications of a whole-time director are concerned, the same provisions which are applicable to a managing director are applicable to the whole-time directors too. Manager. Definition: section 253. Manager means an individual who is subject to the superintendence, control and direction of the board of directors. has the management of the whole or substantially the whole of the affairs of the company and includes a director or any other person occupying the position of a manager by whatever name called, whether under a contract of service or not. Usually, it is a practice to name a person in charge of a section of an organization as manager. Example: shop manager, factory manager, site manager, etc. But these persons are not managers as defined in the Act because they are not entrusted with the whole or substantially the whole powers of the management of the company. Appointment of managing director or whole-time director or management. According to section 254, the appointment of a managing director may be made by any one of the following ways: articles of a company, or by an aid agreement with the company, or by a resolution passed by a company in the general meeting, or by a resolution passed by the board of directors of a company. A requirement of approval of the central government. Usually, the appointment of managing personnel must be approved by the central government. However, a company is empowered to appoint the managerial personnel even without the approval of the central government, but in such case, a company has to fulfill the conditions laid in Schedule 5 of the Act, and a return in the prescribed form shall be filed within 60 days from the date of the appointments with the registrar. Conditions laid in Schedule 5 are as under: non-convicted. The managerial personnel, a managing director or a whole-time director or a manager, should not have been sentenced to imprisonment for any period or to fine exceeding rupees 1,000 for the conviction of an offence under any of the 15 acts mentioned in this schedule, such as the Indian Stamp Act, the Central Excise Act, the Essential Commodities Act, the Companies Act, the SEBI Act, the Income Tax Act, the Customs Act, the MRTP Act 1969, FEMA Act 1999, the Prevention of Money Laundering Act 2002, etc. Not detained in under COFE POSA. That is, he should not have been detained for any period under the contract under the Conservation of the Foreign Exchange and Prevention of Smuggling Acts 1974. Age difference 25 to 70. The appointee must have completed the age of 25 years and has not attained the age of 70 years or the age of retirement specified by the company, whichever is earlier. However, a company can appoint such a managerial person who is below 25 years but above 18 years and above 70 years if appointment is approved by the special resolution passed by the company in a general meeting. If employed elsewhere. If he is employed as a managing or a whole-time director or manager in more than one company, his remuneration should not exceed the limit provided in Section 5 of the Part 2 of the schedule. He should be resident in India when all these conditions are fulfilled. The central government's approval for the appointment of a managing director is not required. However, it is necessary to make an application to the central government within 60 days of the appointment. So, we have understood about whole-time director and the provisions regarding the same. Now, restriction on appointment of the managing directors, which we shall be starting from the next class.